My name's Craig Edmonds. I'm one of the relationship managers here at State Trustees. And today I'll actually be talking about a subject I'm passionate about, and that's powers of attorney. Now, I've actually seen firsthand the impacts on individuals and their families when there's no power of attorney in place, as well as the positive impacts of having a power of attorney ready when people need it most. Now, my colleague, Narelle Lowdell, who's our attorneyships team leader, will actually be joining me on this session today, and we will be sharing our experiences with you and essentially take you on a journey to learn more about preparing and activating your power of attorney. So let's start with the basics. What is a power of attorney?
Thanks, Craig. So what is a power of attorney? A power of attorney is a legal document that allows you to appoint someone to make important decisions on your behalf when you need it most. This can be an organisation like State Trustees, a trusted relative, or even a friend. These documents are like an insurance policy. They are prepared in advance as a precaution in case you need someone to advocate and make decisions on your behalf, as outlined in your instructions to your attorney. Powers of attorney may not need to be activated. However, they give you peace of mind that if something changes in your life, you have chosen who can act on your behalf. So, what are the different types of power of attorney and what do they cover? Enduring power of attorney's financial is where you appoint a person or organisation to manage your financial affairs, including any related legal matters. You can appoint State Trustees as your enduring power of attorney financial. Your appointed attorney can pay your bills, communicate with Centrelink and other financial service providers, manage all your assets, including those of a complex nature, as well as manage your taxes. Enduring power of attorney personal is where you appoint a person or a professional to make non-medical decisions relating to your personal situation and lifestyle. You cannot appoint State Trustees as your enduring power of attorney personal. Your appointed attorney can make decisions about your living arrangements and access to different assisted services. Medical treatment, or the appointment of medical treatment decision maker, is similar to a power of attorney. This document allows you to appoint a person or organisation to legally make medical treatment decisions in the event that you cannot, due to illness or injury. You cannot appoint State Trustees as your medical treatment decision maker. However, there are other organisations who can help, such as the Office of the Public Advocate.
Thanks, Narelle. So what is the difference between a general power of attorney and an enduring power of attorney? A general power of attorney ceases to have effect after you lose decision-making capacity to make financial decisions. An enduring power of attorney will continue even after you've lost the ability to make your own decisions. And for example, if you develop dementia, have a stroke, sustain a brain injury, or potentially even a car accident. So State Trustees prepares enduring powers of attorney.
Why are powers of attorney important? So I like to think of a power of attorney like giving a trusted friend or relative a spare key to your house. You hope that they don't need to use it, but it's good to know that they have it if needed. We can all experience illness, injury, unexpectedly, and as a result, become unable to make decisions and manage our own affairs, hence the need for the spare key. A power of attorney is an important legal document that can be made by anyone aged 18 years and over who have decision-making capacity.
So when we refer to capacity during this video, we are specifically talking about an individual's capacity to voluntarily appoint a power of attorney. So in this context, we're not referring to one's capacity to drive a car or purchase groceries, for instance. you must, in Victoria, have legal capacity, which is decision-making capacity, to make a power of attorney. Now, capacity is your ability to understand the facts, understand the main choices, weigh up the consequences of those choices, understand how consequences affect you and others, and be able to effectively communicate a decision. So your capacity to make decisions can be affected or lost due to illness, disorders such as dementia, or impacts from an accident. Now, your GP or another medical professional should be able to write you a letter of capacity. So don't be embarrassed if you're asked to get one of these. It's actually a protective measure, and it is great because it's ensuring that your wishes are carried out by somebody that you trust. So you must have an enduring power of attorney in place for an attorney to act after you've lost decision-making capacity. It is important to plan for the future and appoint your enduring power of attorney before you actually lose capacity. So if you have been deemed by a medical professional to not have decision-making capacity, you cannot voluntarily appoint an enduring power of attorney.
That often raises questions about when to activate and how you go about cancelling power of attorney. So enduring powers of attorney can be activated when you lose capacity or at any point in time when you may need a little assistance. These documents can also be deactivated, meaning that they're popped on pause, stopped for now, but able to be reactivated down the track, or revoked where there is a discontinuation of the authority. If you change your mind or your situation changes while you have capacity, you can either deactivate or revoke. You need to send a letter to your attorney to let them know that you're cancelling their power of attorney. They may also need or request a letter of capacity to support your changes. And as Craig mentioned, that's a protective measure for yourself.
So what are some of the benefits of having a power of attorney in place? So some of those key benefits of preparing a power of attorney are support from a trusted individual or organisation. So a power of attorney ensures that you have someone that you trust to make decisions on your behalf, providing peace of mind and support in times when you are unable to manage those affairs yourself. It also allows you the freedom to choose your attorney. So you really do have the power and the flexibility to designate a person who best understands your needs and your values, ensuring decisions are made in your best interests. It gives you the best chance to avoid legal worries. Preparing a power of attorney in advance helps prevent future legal complications, ensuring that your wishes are clearly documented and followed. And it also provides financial stability. So with a power of attorney in place that's activated, you can ensure that financial matters are handled responsibly, helping maintain financial stability during extremely challenging times.
So what happens if you don't have a power of attorney? When a person does not have a power of attorney and they have lost their decision-making capacity, the court system here in Victoria, known as VCAT, will step in and appoint someone on their behalf. So could be a person or organisation such as State Trustees, depending on the individual's needs. We encourage you to make a power of attorney while you have decision-making capacity, as it may become too late, meaning that you then lose the right and the ability to choose who's appointed to look after your affairs.
So how can you appoint an enduring power of attorney with the help of State Trustees? You can access our enduring power of attorney document preparation service by making an appointment with one of our professional will writers. It is also common to update or create your will during this appointment. So one of our professional will writers will help you prepare your power of attorney documents. And to make an appointment, you can book online at statetrustees.com.au/book, or simply call us on 1300 138 672. If you do experience difficulties with mobility, or you can't easily get to one of our offices, we can come out to you through our mobile service, but please note that additional fees do apply.
Who can I appoint as my attorney? When it comes to appointing a power of attorney, you can nominate either a loved one, a trusted person, or a professional like State Trustees. As mentioned earlier, some professional organisations can only act on certain types of matters in line with their expertise. Bear in mind that if you are choosing to appoint a loved one, they may not have the skills or knowledge to manage your affairs. That's why having a professional with years of experience in attorneyships, such as State Trustees, can be so valuable. We also have in-house services to help you manage your affairs, including property, tax, pensions, and aged care experts, plus strong relationships with many organisations in these areas. We recommend that you have a substitute attorney or attorneys that can be written into your document. The person you nominate first may decline the role. Also, they may lose capacity or no longer be best placed to make decisions on your behalf when the time comes. Professional attorneys such as State Trustees are a great option, as we always have experts on hand to assist.
So how can State Trustees help you as your financial attorney? State Trustees is here when you need us the most. We remain impartial, without bias, and advocate for your best interest in everything that we do. We support you by ensuring your financial affairs are in good order and that you are well represented. Activating State Trustees as your enduring power of attorney. What's involved in that? So when activating State Trustees as your enduring power of attorney, we will meet with you to learn about your circumstances and lifestyle and why essentially you need the service, or you think that why it would add value to your situation. We seek your instructions on what you would like State Trustees to assist you with specifically around your financial matters. You are then appointed an attorneyships consultant to work with you to determine what your financial needs are. This consultant will be your key contact at State Trustees. They will work with you closely to create a budget, ensuring bills are paid on time and that your instructions are followed. Now, those instructions can change over time. It's very flexible. As long as you have decision-making capacity, you can choose how we assist you and how involved we are. You can change these instructions at any time, as mentioned. So please note, if someone loses their decision-making capacity and their enduring power of attorney is in fact activated, the attorney is responsible for managing the individual's financial affairs. Regardless of capacity, we value our relationships with clients and work closely with them, or their support network, to make sure that their needs are met and that they actually stay involved.
I'd like to now share a case study with you all on financial relief for an aged care resident. We had a client in a scenario where they were a long-term resident in an aged care facility. They were unexpectedly hit with a hefty invoice, which included a large refundable accommodation deposit, as well as outstanding arrears. The total balance was nearly $450,000, creating significant stress for our client, who'd been residing in this facility for many years. This unexpected charge threatened to disrupt their care, as well as their overall well-being. At State Trustees, we recognised the urgency of the situation. We immediately stepped in to advocate for our client on their behalf. Through negotiations, we successfully secured significant reductions in both the refundable accommodation deposit as well as the arrears payments that were being charged. And we established a much more manageable ongoing fee that were then aligned with our client's current financial situation. The outcome, so as a result, of our intervention, our client was relieved of a significant financial burden, making their financial situation more manageable. Through our timely intervention, we were able to resolve a potentially disruptive financial issue and deliver substantial relief to our client, ensuring their continued care without undue financial stress.
Amazing case study. So everyone's situation is unique and may take time to fully address. So if you do have specific questions about your personal circumstances, it's best to reach out to us directly by phone or email so we can provide the right help for you. So once again, please call us on 1300 138 672, or you can email us at generalinquiries@statetrustees.com.au.